Reform Act.
Well, before the abolition of parole with the Sentencing Reform Act, there were no sentencing guidelines. So it's not clear to me why it would be relevant, why a court would be concerned about whether the parolee committed offenses during the period when the parolee was supposed to be on parole after the expiration of the parole term or not. The parolee violates the terms of parole. When the parolee is apprehended, the court would revoke parole and then decide what to do. So why would it be relevant? Suppose your client were on parole. Why would it be relevant to determine whether the additional things that she did while out on parole occurred before or after the 37 months?
I mean, the 1983 regulation explicitly says that if you commit the violation after the schedule ending, it will be considered a violation of parole. So, it's hard to reconstruct exactly what they were thinking, but presumably it was felt that this was important enough to encode it in a regulation. And so, Congress had that regulation on its desk. It was enacted just a year before the Sentencing Reform Act, and Congress eschewed it in the Sentencing Reform Act. So I just think that that's at least some amount of historical consideration is warranted here, especially since I think what this case boils down to are these competing intuitions. The government has this intuition on its side of the house that it doesn't make sense to say that a person who isn't supervised is serving a sentence of supervised release. And then we have the intuition on our side of the house that it doesn't make sense to say that someone could have violated the conditions of supervised release when they're not on supervised release. And ultimately, it's the court's job in this case to cut through that Gordian knot. And I think rather than kind of wrestling with these competing intuitions, I think it's wise to look at the historical tradition here where we see that this just wasn't happening for the entire history of the parole statute. And so the proposition the government claims in its brief is very obvious, didn't occur to the Parole Commission at the time. And so I think the court should carry that tradition forward